Good morning, everybody. I'm your host, the Supreme Litigant, and I'd like to welcome everybody back to Smart Low TV. If you don't mind, please, if you haven't already, go ahead and hit that subscription bell, turn the notification bell on also, and hit that like button. I'll give y'all a second to do that. All right, now in this video, I want to talk about, basically I'm going to show you the case that is proving that just because you file a motion in court does not per se grant that court, so-called court anyway, in personam jurisdiction over your person. This is the case. This is a principle. Even though this is an Alabama case, this is a principle. All right, so y'all pay attention. This is from a video that I did last night during a live. So I'm gonna play this video for you. Where is it? Right here. Let's go. And I'm gonna start reading the case to y'all. This is in a chancery court, which is another word for an equity court. So where we got petition by W.H. Sweeney and others to have a judgment over annulled and vacated for want of jurisdiction of the person. So he's trying to get this judgment vacated for lack of in personam jurisdiction. From an order denying the petition, petitioner appeals. So he appeals the order, the court reversed the judgment and remanded it back down to the lower court. And they're going to explain it to you why. Y'all forgive me if I can't pronounce some of these words. I'm sorry. Leo Trisich, an assignee, filed his bill against W.H. Sweeney and others to enforce a vendor's lien upon a sale of the property and the failure of the same to bring a sufficient amount to satisfy the decree. A judgment over was rendered against the non-resident after publication. So when they say after publication, they're talking about service by publication. Service by publication is basically you are attempting to serve the defendant because you can't find them, so you're attempting to serve them in the public newspaper in a particular county or city where they live, even if they don't see it. As long as you did it for, like, some states might require you to do it for like 4 weeks or something like that. Once you do that, then they'll go ahead and issue a judgment for you. And particularly, this would probably be a default judgment. No personal service was had, so they never perfected service of process against him. So let's see. And I think this is their argument right here. So the appellant, it says wait a minute, hold on. Well, this is the appellant. Okay, a court which okay, so this is what they're doing. This is the appellant's argument right here. This is what he's arguing right here. And I think on down you will see the appealee, and you're going to see their argument, and then you're going to see what the court held. Okay, a court which has made a final order or decree, which on the face of the record or proceedings is void, should vacate it whenever its attention is called thereto by appropriate application for that purpose. So they're telling you that that's what you have to do if the judgment is void. After the expiration of the term at which a judgment is rendered, the proceedings in the cause are final and the jurisdiction of the court is exhausted, except for amendment or the correction of clerical misprision, the record furnishing the evidence therefore. Where are we at? Okay. The appearance for the purpose of making the application, meaning the motion to vacate the judgment. He made an application in the manner of a motion to vacate the judgment. So he made that application on a special and not general appearance as to give the court jurisdiction of his person. So he made a special appearance, not a general appearance. Appeal will lie from order refusing to vacate a void decree or judgment. So they're telling you that you can appeal it. And whenever they're refusing to vacate a void judgment or decree, you can appeal it. That's what they're saying. And these are all Alabama cases, just to let y'all know. But this is where y'all need to go to read and to understand what's going on. You need to go and read these old cases. And although I'm reading an Alabama case, this does not just apply in Alabama because this is a principle. Service of process is due process. They have to give you due process. Anytime they violate well, I ain't gonna say anytime, but it seems like generally speaking, it depends on what type of process is due. But I know like service of process, you can vacate a judgment when they fail to perfect service of process on you. You can vacate that judgment. Okay, the appealee. Now this is what the appealee is arguing. Under its allegations, the petition was wholly insufficient and defendant is barred by lashes. That is an equitable remedy. That is an equitable affirmative defense. And by the statute of limitations. So that's what the appealees is arguing, not the appellants. Under section 859, code 1896, an execution issued for the balance found due after sale. The decree over is within the, I'm not sure what that is, the lis pendens, and further notice is not necessary. So we're going to go down. If I'm not mistaken, this is what the so-called judge is holding. This is what they're going to say. This is the ruling right here. Upon bill filed to declare and enforce against a non-resident, as shown on the face of the bill, a vendor's lien, a decree was rendered granting the relief prayed. So they granted what he was wanting. They granted him the relief he was asking for, his remedy. And after sale of the property subject to the lien, a balance of the indebtedness found due remain unsatisfied. Thereupon, without other notice at any time than by publication. So they served him by publication, like I just mentioned earlier. A personal decree over for such balance was rendered. After the lapse of 10 years, after the lapse of 10 years, the defendant, still not a resident, petitioned the court in which the decree over had been rendered to vacate it on the grounds that such decree was void, since he was not brought into court by personal service. Pay attention, y'all. The petition was dismissed conditionally. It has been settled since the leading decision, and y'all might want to go in. I'm going to highlight this for y'all. Y'all might want to go and read that case right there. It has been settled since the leading decision, I'm not really sure how to pronounce it anyway, was pronounced that a personal judgment or decree rendered in a cause against a non-resident upon whom no personal service therein was had is void. Of course, and of course, unenforceable in any manner. That doctrine has been several times affirmed by this court. While a court is without power to alter, vary, or annul final judgments or decrees after the close of the term at which rendered, except for the correction of clerical misprison or amendments, the evidence of which the record affords, yet where it appears on the face of the record that the judgment or decree is void, either for want of jurisdiction of the subject matter or of the party. When they say of the party, they're talking about personal jurisdiction. They're talking about in personam jurisdiction. It is the duty of the court upon application thereto by the party having rights and interests immediately involved to vacate such judgment or decree at any time, subsequent to rendition. And this, out of a due regard to its own dignity, the protection of its officers. I wonder why they say the protection of its officers. Probably because they were not being entitled to any form of immunity. That's what I'm getting. And the prevention of abuse of its process and of injustice to its suitors. So on down some more. I'm almost finished, y'all. We got about 2 or 3 more pages. Let's see. And it appears that this court has repeatedly, in the cases referred to, recognized the right and the propriety of appeal, whether the order to vacate be granted or refused. The decree here in question being, as shown by the face of the record in the original cause, utterly void, the application of Sweeney should have been granted. This man waited 10 years to petition to vacate a void judgment, and they still granted it. 10 years. Sorry if I'm so loud, y'all. I'm sorry. Should have been granted unless as insisted by appealee. So pay attention, because this is what the appealee is arguing. Pay attention. The appealee is going to start arguing what people have been saying, and I'm telling you all that you're wrong. As insisted by the appealee, the lapse of the time has affected his rights in the premises, or unless his appearance by filing the motion under consideration gave the court jurisdiction of him as a party defendant in the original cause, and justified the reopening of that cause and the rendition of a judgment against him. Pay attention. In our opinion, neither of these contentions can be sustained. In our opinion, neither of these contentions can be sustained. So they're saying, no, we don't agree with that. We don't agree with that. Just because he filed a motion, that does not give this court jurisdiction. Just because he filed a motion to vacate a void judgment. That's what they're saying. With reference to the first proposition, this court in Pettis versus, not sure how to pronounce that anyway, and also in Baker versus Barcliff, declares unequivocally that the lapse of time can have no effect to qualify the right to have a void decree, void as shown by the face of the record, vacated. So you can vacate that void judgment whenever. This man waited 10 years, y'all. 10 years. To the same tenure is the announcement of the court in Chamblee versus Cole, Alabama 128, 650. Let's see, right here. And stating the principle in its breath, discussing the void decree. Freeman on Judgments in section 117 says, for if it be null, no action upon the part of the plaintiff, no inaction upon, let me rephrase that. I'm gonna read this to y'all. I got to highlight this because I need y'all to see this, man. Y'all got to pay attention. For if it be null, no action upon the part of the plaintiff, no inaction upon the part of the defendant can invest it with any of the elements of the power or validity. In accord with the foregoing is 23 encyclopedia, so they must be citing a legal encyclopedia. And cases cited in note 16, the appearance in this proceeding was in no sense an appearance. So he filed the motion. They said that's still not an appearance because he filed the motion. Y'all see that right there? Let me highlight that for y'all again. I need y'all to see that. The appearance in this proceeding was in no sense an appearance. General or special. So they saying he didn't make a general appearance or a special appearance in the original cause in which the void personal decree was entered. That cause had in an orderly manner progress to a valid decree declaring the lien and effecting the sale. Without the jurisdiction possessed in the cause, there being none over the party defendant, therein warranting a personal decree over or against him, that cause had run its course, and the court had fully and wholly exhausted its powers, except only for amendment or correction of clerical mispresence, the record affording the evidence thereof. Let's go down. But if the rule stated were not so conclusive, it would smack of gross injustice, as well as make the court a party to the misapplication of its powers and processes, to fasten its jurisdiction upon one not lawfully within it when he comes to relieve himself of the void decree of the court, and at the same time to conserve the interests of all parties and the dignity of the court. Such a practice, if permissible, would invite the assumption of jurisdiction of a person not subject to it but who was brought within its reach by the illegal and void act of the tribunal seeking its judicial power over him. Let's go down some more. The result would be that in every case where there was an unservable defendant, a judgment could be rendered and thereby compel him to let the void judgment stand unquestioned and unremoved, unless he were willing to submit to the jurisdiction of the court. The law is otherwise, regardless of the merits of the matter in which the decree or judgment was or was desired to be rendered. It follows that the motion to vacate the judgment should have been unconditionally sustained and its prayer granted, and that the proper orders may be entered below. The decree appealed from being reversed, the proceeding will be remanded to that end, and that'll be it for that. But I had to let y'all know that. I had to let y'all know that a void judgment is a void judgment. That's just all it is. A void judgment is a void judgment. Okay, y'all. So as you can see, just because you file a motion in court does not per se grant that court in personam jurisdiction over your person. Just to let y'all know, there's some other things that were mentioned in this video, but I won't get into them right now. There's some stuff that I would need to study so that I can articulate it to you in a manner in which you can understand it. But anyway, hopefully this helped y'all out. That will be the end of this video. The Supreme Litigant is out. Peace.